Hi, my name is Jim Neuberger, and I'd like to talk to you today about alcohol and drugs and the consequences of driving under the influence of one or both and being arrested. Driving under the influence of alcohol or drugs is a serious criminal offense in the state of Georgia. A person can be convicted of driving under the influence of alcohol if they have a blood alcohol content of more than 0.08 grams %. The law says that if you have an alcohol level of more than 0.08 or 0.08, then you are presumed to be under the influence of alcohol while you're driving. You can also be convicted of driving under the influence of alcohol if you have a lower blood alcohol content, but you're proven to be under the influence of alcohol to the extent that you are a less safe driver. For example, if you have a car accident and you've got an alcohol level that's under 0.08%. You can also be convicted of driving under the influence of drugs, not just what you hear about in terms of street drugs, cocaine, marijuana, heroin. You can be convicted of driving under the influence if you're using a prescription medication and it makes you a less safe driver. For example, it's not a defense if a doctor prescribed a sleeping medication, you take it at 10 o'clock in the morning and then have an accident because you fall asleep at the wheel. You can still be convicted of driving under the influence of prescription medications. Georgia sets the minimum drinking age at 21. However, if you're under 21, the amounts of alcohol that are permissible in your system go all the way down to 0.02%. In other words, the state does not want people under 21 drinking and driving. Punishment for DUI can be very severe. At a minimum, a person convicted of DUI is facing a year in jail or up to a year in jail, thousands of dollars in fines. They can incur thousands of dollars in legal expenses, be required to perform 40 hours of community service, have their driver's license suspended for up to a year, and be required to go through alcohol and drug evaluation and testing. If it's determined through that testing that someone actually has a drug problem or an alcohol problem, then they may have to go through treatment. People convicted of DUI also very often have to go through a DUI school, which costs hundreds of dollars to get their license back. If you're convicted of DUI, you can also face civil penalties. Criminal cases involve the state of Georgia prosecuting somebody and having to prove beyond a reasonable doubt that they committed a criminal offense. A civil case is different. In a civil case, the person that was injured by a drunk driver can sue the drunk driver to recover monetary damages. It's by a preponderance of the evidence standard, and the state's not involved. There's no risk of jail time in a civil case. Insurance companies will cover most automobile accidents if you have automobile insurance. Homeowners insurance, for example, will not cover you if you have a car accident. Most insurance companies will cover the injuries that are caused by a drunk driver. So if a drunk driver hits another person and causes an injury, the insurance company will step in and pay for a defense and pay for the damages caused by the drunk driver. Some, but not all, insurance companies will also pay for what's called punitive damages. Punitive damages are a monetary award against the drunk driver that are intended to punish or deter that person and keep them from doing the same conduct again in the future. Not all insurance companies will cover punitive damages. I've been practicing law for 16 years. The focus of our practice here at Neuberger Law is helping those people who have been injured in automobile accidents, and with a focus on helping those folks who have been injured by drunk drivers. If you, your friends, or your family have been injured by a drunk driver, please feel free to give us a call. We'd be happy to try to help out. Gracias a todos y muchos cuidado.